Hello, everyone, and thank you for joining Automation Alley's podcast today on the U.S. Patent and Trade Office. We're going to talk about some of the services they offer to companies that are interested in protecting their trade secrets as well as monetizing them. With me today is Mr. Damian Porcari, Regional Director of the Midwest Regional U.S. Patent and Trademark Office. Damian, thank you so much for taking the time to be with us. I feel like I've known you for a long time in our brief discussion leading up to this interview, but in the 20 minutes that we have, I thought maybe a good point of departure would be to talk about your background before you joined the U.S. Patent and Trade Office.
Sure. So yes, my name's again Damian Porcari. I'm the Regional Director of the Elijah J. McCloy Midwest Regional U.S. Patent and Trademark Office. I joined the PTO in 2018. So before I worked at PTO, I worked for Ford Motor Company as in-house counsel for 27 years. Handled a lot of technologies, but my background is chemistry, so I did a lot of the engine, fuel cell, battery technologies, as well as manufacturing and design patents. And I did patent prosecution, where you prepared and wrote patent applications, a lot of litigation. And towards the end of my career at Ford, I was the Director of Licensing and Enforcement, so a lot of litigation and licensing activities. And before that, I was with the U.S. Army Tank Automotive Command in Warren, where a lot of the contracting and research was for tracked and wheeled vehicle applications.
Interesting. So I guess we can talk a little bit about the roles and responsibilities of the U.S. Patent and Trade Office and the services that you provide to companies that are interested in protecting their trade secrets as well as monetizing their intellectual property.
So yeah, so the U.S. Patent and Trademark Office, essentially we have two principal responsibilities. We examine people's patent applications and we examine their trademark registrations. There isn't an office that records trade secrets. We don't want them. You don't give them to us. We do advise the President on all intellectual property matters. That includes patents, trademarks, as well as trade secrets and copyrights. The President oversees all of the responsibilities of the federal government, so we're a bureau within the Department of Commerce. So our function is in that area. So the USPTO, the U.S. Patent and Trademark Office, we have 5 offices, one in Detroit, that was created in 2012, as well as an office Denver, Dallas, and San Jose, and our headquarters is in Alexandria, Virginia. So there's about 13,000 employees and staff. Most of those are in the Patent Examination Corps, and then the next big corps is in the Trademark Examination Corps.
Okay, so you sort of anticipated my next question. Can you sort of demystify the difference between
Sure.
the various types of intellectual property? We have copyright, trademark, and patent.
Yes. So those are the principal ones as well as trade secrets. So the first 3 you mentioned give you a piece of paper. And we still get pieces of paper. So patent applications, if it issues, you actually get a patent certificate. You then use that certificate if you're going to enforce your patent in court. Trademark gives you a trademark registration, same thing. You're going to use that if you're going to enforce your trademark. And copyright also gives you a copyright registration if you're going to enforce it. So the first 2, patents and trademarks, there's a person within our office, the patent office or the trademark office, that actually looks at your invention and determines whether or not it meets the requirements for patentability. Is it new, non-obvious, over the prior art? Did you describe it well? Did you claim it accurately? And is it eligible for being patented? If it is, then you get a patent from it. In the trademark realm, the United States is an actual use country. Most of the world is an intent to use, but we actually require that you use the trademark and the brand. So the difference between a patent and a trademark is a patent covers either a composition of matter, a process, a machine, or in more unusual cases, a design, an ornamental design, or even a plant. So you can patent a plant. Okay. So those are, articles, and a patent has a term, either a design term of 15 years or a utility term for utility patents of 20 years. A trademark is different than an invention or a patent. A trademark describes the source of goods, the entity that is producing a service. So it's more thought of as either a name or a mark.
Sure.
And so a trademark can last indefinitely as long as you're continuing your business or selling your service.
Right.
So the difference between a patent is it's meant to protect an inventor for a period of time to encourage them to share their ideas with the public.
Mm-hmm.
And the purpose of a trademark is to say this product, whether it's a lamp or a cup, came from this corporation, so that the buyer of that cup or lamp knows who made it.
Okay.
So it's more a source identifier and protects the public so that when they see that mark, that logo, that brand, they know which entity made it.